Hearsay Exceptions. Rule 801D1, prior statement by witness. 3 exclusions. Offering for its truth, the jury can consider it for its truth, not admissible for non-truth as impeachment, but for substantive evidence. Prior inconsistent statements, prior consistent statements, prior identification. Rule 801G2 makes the admission doctrine admission by party opponent. 5 exclusions. Rule 803, hearsay exceptions, availability of declarant and material. Rule 804B, hearsay exceptions, declarant unavailable if invoked only if the declarant is unavailable as a witness under 804A, such as being dead, suffering from serious lack of memory privilege, not to testify, absent, etc. 807 residual exceptions is a catch-all exception so that it does not fit any other exception. If it can meet this rule. Prior inconsistent statements. 801D1A, prior inconsistent statement made by a witness is not hearsay if 3 conditions are met. The witness must now be cross-examinable concerning the prior statement, not the event. The statement must be inconsistent with his present or current testimony, and 3, it must have been made under oath in a prior proceeding or deposition. Advisory comment note: if witness admits on the stand that he made this statement and that it was true, he adopts the statement, and there is no hearsay problem. The hearsay problem arises when the witness on the stand denies having made the statement or admitted having made it but denies the truth. If elements are not met, then can still come in for impeachment purposes but not for substantive evidence because it is hearsay with a limiting instruction. Here's the State v. Smith case from 1982. The facts were Conlon was assaulted and wrote out a statement of police reform which she named Smith, defendant, as her assailant. She signed under oath, penalty, perjury before a notary. A month later, she named another man as her attacker. The issue was, what does other proceeding mean? A proceeding ensures the guarantee for a minimal amount of truth so a statement will be reliable. Preliminary and administrative hearing would be proceeding. Also takes care of the ambiguity problem by ensuring statement was actually made. Holding other proceeding under the rule would clearly cover the other 3 methods: finding probable cause, instructions to reinstate the verdict, the jury sentence. Grand jury statements are included as prior proceedings. Problem 4A. I got amnesia. Statement made in a proceeding. Grand jury proceeding qualifies, although it wasn't cross-examinable at the time of the grand jury proceedings. Then the person is cross-examinable now. Witness said he got amnesia. Is that inconsistent? Yes. Court says statement is inconsistent, conflicts with my implication. Inconsistent one of the statements contains something the other statement doesn't have. Pointed versus specific, qualified versus general. Categorical and uncertain. Prior positive statements claimed a lack of memory at trial. Prior consistent statements, 801D1B. Prior consistent statement by a witness is not hearsay if 3 conditions are met. The witness must be cross-examinable at trial concerning the prior statements. The statement must be consistent with his present testimony, and it must be offered to rebut a charge of recent fabrication or improper influence or motive. Under this rule, they are substantive evidence once pre-motive requirement is met. These prior consistent statements only come in after there's been an impeaching attack that raises a charge of recent fabrication or improper motive. The rule is tied to testifying impeachment by bias. Preferences for live witness testimony. Tome versus United States. Tome convicted of sexually abusing a 4-year-old daughter. AT did not talk about the abuse during the trial. Government offered testimony with 6 witnesses describing 7 statements that made by AT. Prior statement admitted. Trial court convicted the defendant. whether out-of-court consistent statements made after the alleged fabrication or after alleged improper influence or motive arise,